Welcome to Consumer Law. What is it good for? Brought to you by Stormcatcher Law. And in this video, I'm going to look at vehicle inspection reports and expert evidence in general. And the opening question, there's going to be a few questions we're going to incorporate into this video, but the opening question is, are expert vehicle inspections biased and are they worth the paper they're written on? And the background of that question comes from a letter sent by a car finance company to the questioner, and it says this: to determine the cause of the issues and when they occurred, we commissioned an inspection to be completed by IVIS, who are an independent, impartial vehicle inspection provider used throughout the UK automotive industry. The letter goes on to say, we're not upholding your complaint as we have an independent report which confirms the issues that you have mentioned are not the responsibility of the selling dealership. Therefore, I cannot hold them responsible for the rejection of the vehicle. So at its centre, there are lots of questions, but there are 5 key questions, I suppose. First, are experts impartial? Second, is it the experts that's making the decision, or the car finance company or dealership? 3, is it enough for an expert to simply say the fault was not present or developing at the point of sale? 4, are expert reports indisputable evidence? Is it written and therefore it is so, or can you challenge them? And number 5, what is the scope of an expert report? How far can an expert go? So a little bit more background, and you probably know this if you're watching this video, that the car finance lenders in general, warranty firms and car dealerships have come to heavily rely upon expert evidence and vehicle inspections, and they use generally, not always, firms such as Automotive Consulting Engineers, IVIS, that's the firm that's referenced in the question, Scotia, DEKRA, independent vehicle inspection services, which are also known as IVIS. But there are many others out there. These seem to be the most popular, or at least most of the questions we've had are involving reports from these people. Now, the prevalence of these reports and these particular firms in giving these reports has understandably led to lots of customers wondering how independent and impartial these firms are, and whether the use of these reports by dealerships and car finance lenders is really just a shortcutting process to proper complaints handling and therefore undermining your rights. And in this video, we're going to look at some of the rules, not all of them, there's a lot of them out there, so that you can make your own mind up about your circumstances. So number 1, are the experts impartial? So we look at another question that touches upon this, and this comes from someone who says, I've been told by a motor trade membership firm acting for a car dealer that the expert they want to carry out the vehicle inspection is court approved. Is that true? Well, the short answer is no. Vehicle inspection firms, vehicle experts are not court approved. There isn't a list of these firms that the courts have somehow vetted. In my view, what's happening is that the dealership, or the firm that's looking after this dealership anyway, is trying to convince you that the expert they're using is authoritative, that somehow has been vetted by the court, and therefore that their word or the opinion is going to be of some significant value that you won't be able to disagree with. For me, they're trying to mislead you. And as a consequence of that, the impartiality of the expert or the report itself is going to be questionable. What is true is that all expert reports intended to be relied on in evidence or as evidence in court must comply with Part 35. These are the rules in the civil procedure rules that govern experts and expert reports. However, expert reports can only be used in evidence in court with the permission of the court. So it's not automatic as far as that's concerned. As to the central question of bias, This is understandably a big deal, because if there's bias, then both the expert and his report or her report is in trouble. There will inevitably be questions about the independence and impartiality of vehicle inspection services, who are regularly instructed by high-volume clients, such as finance companies and large dealer groups, as I've said before. But this, in of itself, is not demonstrative of them being biased. The report must be, this is one of the key issues, the independent product of the expert. It is not there to support the position or the claim of the instructed party. When experts starts to do this, when they advocate for the people that are instructing them, then it's going to be quite difficult for them to convince anybody else that they're independent and impartial. Next, number 2. This is the question as to whether or not it's the expert deciding the complaint rather than the finance company. I have to say, in the first question, when I read out the section from the finance company, it did start to look like that the finance company was saying, look, we don't have any choice in this. The expert said the problem wasn't present or developing on delivery. What else can I do? Remember, the letter says we're not upholding your complaint as we have an expert report which confirms the issues are not responsibility to the dealer, and therefore I can't hold them responsible for. I have to say, I had an email myself recently from the Financial Ombudsman Service, which said, and there was an expert report, a vehicle inspection report that was submitted by the finance company to the Ombudsman Service, and the Ombudsman Service said, we have this report, we have no choice but to take notice of the findings. So that starts to look like the expert is making the decisions, not the people using the expert evidence as evidence in deciding the case. But the reality is, no, the expert naturally is not the decision maker. The purpose of the automotive engineering expert is to provide information and an opinion on aspects of the complaint which may help the decision maker draw their own conclusions. But importantly, a judge, an ombudsman, a complaints handler is not compelled to agree with the conclusion of the expert. They can make up their own mind, and there may be cases where judges deem there's no need for expert evidence, that they can decide the case based on their own knowledge and experience and expertise. So we have to be careful when you start to read these documents from Ombudsman Service, from finance companies, from car dealership, that simply go to the bottom of the report and look at the very last line that says this was not present or developing at the point of say, and therefore that's it. That's the end. That's the end of the story. Thirdly, another question from another questioner. The expert says that further dismantling of the engine will be required. However, this is the conclusion, the fault was not present or developing at the point of sale. So this goes on a bit from our previous point, is that enough? Can an expert just say night follows day? Can an expert say Monday follows Sunday? Is that enough in itself to give a bland statement of their opinion and for that to be taken as fact? No, is the answer. If you start to see those in your reports, that is not sufficient. Any report that centres around an unsubstantiated statement like that is as good as useless. For example, this is another common one, but somebody else that's written in, that the expert wrote in their report, I quote, the vehicle has driven 9,000 miles, which it couldn't have done if it was faulty. That's no more than a generalisation and completely discounts the possibility of some latent defect or a manufacturing fault, which understandably could go on unnoticed for some considerable time. If the expert doesn't explain the reasons for their conclusions, realistically, it can't be relied upon. Fourthly, which deals with whether, which follows on from the previous point really, is to whether an expert report is somehow indisputable. That if an expert says it is, it must be. And there is a sense, as I've just said before, and in fact I'm fairly confident that car finance complaint handlers, the Financial Ombudsman Service, and some lawyers just simply say, well, that's it. The expert says it's that, and therefore it must be. That's not true. There is no rule which exempts an expert from being challenged or the content of the form of the report being questioned. This is particularly important in circumstances, as I mentioned before, where there is just that bland statement of conclusion without any backup. It must be challenged. I had a case earlier on this week where exactly that. I had to go back to the Financial Ombudsman Service and explain to them that there is no reason whatsoever for this expert to conclude that the failure of the engine in that particular case, which is a common feature, is simply as a result of in-service wear. I had to explain that in order to come to that conclusion, the expert would have to determine how long that engine is intended to last, which is a couple of 100,000 miles in that case, whether or not the vehicle had been properly serviced and maintained or not, and what difference that may have on that life expectancy. All of that must be able to take into consideration before someone can just discount the possibility of there being any form of defect for which the finance company or the dealer can be liable for. So you have to question everything. Without that, these reports will go unnoticed and be relied on without being challenged. Now we get on to the last aspect, which is what is the scope of expert evidence? How far can an expert go? And this comes from a questioner, which I won't read out the entirety of their question, but they received a lengthy report, and I won't tell you from which firm it was. It wasn't one of the ones I was just mentioned to, funny enough, which is a mixture, very long report, very long indeed, but it includes aspects of law and the interpretation of various breach of contract, misrepresentation, negligence. It questions the reliability and the truth of both the complainant, who's a consumer, and also the reports, the mechanics, information that they've been provided. The short answer is experts should stay in their own lane. I've seen many reports on behalf of warranty companies and car finance lenders, which include what seems to be the questioning of the complainant, because often the car is at the complainant's premises, so they meet the opposing expert, and the expert has effectively questioned the complainant, asked them for information, challenged whether or not that information is true or not, almost taking a statement from the customer. It is not okay for an expert to cross-examine the complainant. It is also not okay for someone to unfairly criticise the opposing evidence or the reports of the complainant, or to belittle those reports because they are just a mechanic or they're just a technician that works in a main dealership, that somehow they're a subspecies. It is not okay. It is not okay, in my opinion, for an expert to give their opinion on whether the report of the opposing party, the claimant in that case, is somehow compliant with Part 35 of the Civil Procedure Rules. That's not their job. This is an expert who is giving an opinion on the law, even though they're not a lawyer or a judge, and arguing the case for their instructed client as if they were an advocate. Well, that would, of course, undermine their impartiality. This is not the role of an expert witness. It's not their area of expertise, and it can lead to those reports being discounted and being worthless and a complete waste of money. So in summary, there's a lot going on here. But if you have a complaint that has been declined by a finance company or the Financial Ombudsman Service or the Motor Ombudsman Service or a car dealer, a car dealership, in reliance upon an expert report from any expert, this isn't about these firms particularly, it's in general, but if you hear that language, which is just a short report, and I've seen many of them that says the fault was not present at the point of sale or present or developed at the point of sale, without any explanation of how they've arrived at that conclusion, or they've excused it as simple wear and tear, there's every possibility that that's not an expert report at all. And if there's aspects of those reports that give you the impression that somehow the expert is advancing or doing their best to advance the case of the opposition, the car dealer, the finance company, otherwise, then at the very least, you may benefit from having these reports looked at, having your complaint assessed. And to do that, you can give us a call here on 0333 700 7676 or drop us an email at knowledge@stormcatcherlaw. If you have any further questions, let us know.